Right, good afternoon, ladies and gentlemen. Here we are back in the room. We had a successful site visit this morning. The weather was beautiful, if not very cold, but yeah, visibility was good. So we're coming to the end of the inquiry process now, and we're going to be hearing from both parties in closing. And as I think I explained before, closing is the advocate's draw to, it's all right. The advocate's skill is that they draw together all the threads of the arguments and the evidence and the points conceded or whatever together to present their case as they would like me to consider it. Now, just a couple of housekeeping things before we finish. If you've got a mobile phone or a pager, please make sure it's switched off or onto silent. There's no fire alarm test today, so if the alarm goes off, we have to exit the building. I think I can probably deal with that. We go out through the doors behind us, behind the council there, and follow Mrs. Moulton, basically. Thank you. Right. Anything that come up overnight anybody wants to raise? No? Mr. Willers? No, thank you. Okay, so we're going to, yes, Mr. Mannering.
Excuse me. Yeah, it's just a correction of the position of the bus stop on the amended latest plan. The west-going bus stop is not in the position that it's shown on the plan.
Right. When I was at the site visit, I did take note of the position of the bus stops. So, yeah, be assured I have that straight.
If it's an amended document, it should actually be corrected.
Okay, thank you. Right, so I'm going to ask Mr. Smythe on behalf of the council to present his closings. Thank you.
Thank you, ma'am. It is common ground that the appellants purchased the site at auction in August 2017 and began the unauthorised residential use in May 2020. Whilst the planning system allows retrospective planning applications, the ministerial statement makes clear that decision makers can take into account the manner in which the breach of planning control arises. Here, the establishment of the Gypsy Traveller site was plainly calculated and well planned. It's common ground that whilst in the past this conduct would be immaterial, it is now a material consideration which weighs against the appeal. The High Court was sufficiently concerned about the risk that even more work be undertaken to expand and entrench the site that it granted an injunction to hold the ring and prevent any further breaches. The council continues to harbour doubts about the justification given by the appellants. It's their case that there was a pressing need for a settled base as their existing living arrangements at the Withen Lane and the Feeney sites were seriously suboptimal. Notwithstanding that they are not wealthy, they clubbed together to buy the site in August 2017 to provide the settled base which they longed for. Mr. Clee told the inquiry that he had to resort to borrowing money from his cousin, Miss Charlene Fury. It is surprising in these circumstances that they waited 10 months before submitting their first planning application in June 2018. When it became obvious that it was likely to be refused, it was withdrawn in November 2018. If they really were desperately keen for the settled base, one would have expected the revised planning application to have been made promptly. In fact, the appellants did not submit it for another 6 months. This was refused in June 2019. The appellants decided not to appeal the decision. They waited a further 11 months before submitting the third planning application in May 2020. This is not eloquent of a group of families keen to do all they can to obtain permission to live on the site. In fact, the impression one gets is that there was very little urgency in trying to realise the aspiration to residentially occupy the site. Ultimately, the appellants occupied the site 33 months after they bought it at auction. It is submitted that the objective timeline is inconsistent with the appellant's justification for jumping the gun. Given the existence of the injunction and the fact that the merits of the site were subject to an appeal, one would have expected the appellants to have been on their best behaviour. Their conduct over the last 18 months since the site was established is not eloquent of an appellant carefully and assiduously doing all he can to fully obey the rules of the planning system. Prior to the occupation, the appellants went to the trouble and expense of instructing Mr. Brown to draft a layout plan for the proposed development. In fact, the appellants jumped the gun and began the residential occupation of the site within a matter of days of the layout plan being drawn up in May 2020. The existing layout bears little relation to the layout plan. The position of the caravans and the stables in particular are materially different. No good explanation has been advanced as to why there is such a significant departure from the layout plans. Given that they had waited 33 months before moving onto the site, it's surprising they did not remove the existing structures from the land prior to occupation. In cross-examination, Mr. Cleese suggested it was because the injunction prevented him from doing so. That is not right. The injunction does not prevent or restrain the stables and caravan from being moved around the site. Given the passage of 18 months, it is surprising that no real steps have been taken to ensure that the layout of the site faithfully reflects plans which form the basis of the application. Mr. Brown has not sought to amend the plans. The appellants have not sought the consent of the council solicitor in accordance with paragraph 1 of the injunction to undertake works to bring the site in line with the plans. Ma'am, you are invited to infer that the discrepancy arises because the appellants are not truly motivated to follow the layout plans. If they cannot bring themselves to follow the plans now, within the currency of this appeal, what chance is there that they will be inclined to follow it faithfully post-decision, or indeed they'll obey all the conditions which may be imposed? Further, without seeking professional advice, Mr. Clee planted conifers, which everyone seems to accept is not an appropriate or sympathetic choice of species for this location. Mr. Brown would have recommended native species like hornbeam. Again, this is eloquent of a slipshod approach to planning. Without first seeking the view of the council or his own planning consultant, Mr. Clee went ahead and did what he thought was best. There are strong grounds to suspect that the appellants subject to the injunction have breached it. Paragraph 1 of the injunction is crystal clear. The defendants are forbidden from erecting any structure or building on the land. It's common ground that post-injunction, the stables and children play equipment were erected. The council solicitor did not give written consent for these structures. Therefore, there was a clear breach of the injunction. Mr. Willers suggests that as the stables are mobile, i.e. capable of being moved, they are not covered by the restraint against erecting any structure. It appears to be his position that one cannot erect a mobile structure, and therefore, as the stables are mobile, it is not caught by the injunction. That is unattractive semanticism. The stables is plainly a structure rather than a building, and the purpose of the injunction was to hold the ring and maintain the status quo. The contention that the introduction of a structure which is bigger than the caravans is not a breach of the injunction is implausible. In respect to the stables, it's averred that Mr. Clee sought and was given verbal permission by the enforcement officer, Mr. Lehman. This is fanciful. Why would Mr. Lehman spontaneously give verbal consent for the stables without first speaking to the council solicitor? It makes no sense that he would have done it. And it is surprising there was no follow-up email confirming follow-up email confirmation of what had been sanctioned, particularly given the serious consequences of failing to obey the injunction. The council does not accept that this oral consent was provided, but even if it was, it would still be a breach of the injunction, as the injunction is specific about the identity of the person who can sanction an exception, i.e. the solicitor only. Mr. Lehman simply had no authority to consent to the stables. This is crystal clear on the face of paragraph 1 of the injunction. Mr. Lehman gave evidence that he did not give permission for the siting of the stables, as stated by Mr. Clee the day before. He explained that he had no recollection of giving this consent, and if he had said it, he would have recalled it, as it was important given it related to the injunction. He went on to explain that this was the first injunction he's ever been involved with. The inquiry is therefore faced with a striking dispute of fact. Ma'am, you are invited to prefer the evidence of Mr. Lehman. He is an experienced enforcement officer who has no reason to lie. He was the main enforcement officer dealing with the site, and it is intrinsically improbable that one, he would have given such consent off the cuff when he had no authority to do so, and two, that he would then forget about having sanctioned the introduction of the stables. Mr. Willers was offered the opportunity to cross-examine him, but chose not to. Standing back, it is far more likely that Mr. Clee is not telling the truth than Mr. Lehman. The latter has no reason to lie. The former has every reason to explain away the breach of the injunction. What is the upshot? It means that false and misleading evidence has been provided by one of the appellants. No apology has been forthcoming, nor has there been any attempt to correct the record. Given that he has been caught out in such a blatant lie, Ma'am, you should approach the rest of Mr. Clee's evidence with considerable caution. Further, the appellants accept that they did not give any forewarning to the council in respect to the play equipment at all. No defence to this element of the allegation has been articulated whatsoever. So that element, Ma'am, stands unimpeached. So where does this leave us? The manner in which the site was established and the unattractive track record of compliance reflects very poorly on the appellants. This conduct detracts not only from their credibility, but also means that you, Ma'am, can have little confidence that any conditions attached to a permission intended to mitigate a harmful impact will in fact be complied with. And I ask rhetorically, if the occupants don't obey the injunction, what hope is there that they will obey a breach of condition notice should one be served? Turning to the landscape objection, it's the council's case that the unauthorised site gives rise to an unacceptable impact upon the local landscape and thereby conflicts with CSP 7. The site occupies a sensitive location in the local landscape. The site enjoys protection under local planning landscape designation and area of landscape enhancement. The unauthorised development causes significant harm to the character and appearance of the area. The 2-metre high acoustic fence in particular is a conspicuous and incongruent feature which enhances a sense of enclosure and isolation, contrary to PPTS paragraph 26D. It is submitted the appeal offends policy N20 as it is likely to further erode the character or quality of the landscape. It's the appellant's case that neighbourhood plan DC2 supersedes policy N20. In accordance with the framework paragraph 30, this can only arise if N20 conflicts with DC2. This plainly does not apply. Both policies pull in the same direction. They do not contradict one another. For sure, there is a difference of emphasis, and DC2 is drafted in permissive language, but this does not mean that the two policies conflict with one another. You, Ma'am, are invited to give full weight to both of them. Penultimately, Ma'am, the accessibility of the site, whilst its rural location is not unacceptable as a matter of principle, in this case, the site is marooned off the A53 such that its occupants will inevitably be dependent upon the private car. There is no realistic public transport option for the site whatsoever, given the dangerous walk route along the A53, which is unlit and lacks a pedestrian walkway. This serious deficiency renders the site unsustainable, notwithstanding the benefits which properly weigh in its favour. In cross-examination, Mr. Brown appeared to agree that the route to the bus stop would be unattractive for site occupiers, but relies upon the planning junction improvements as part of HS2 Phase 2, which he concluded would significantly improve the position. But, Ma'am, this is hopeless. Mr. Brown really was clutching at straws. In response to a question from you, he could not say when the government expected that the junction improvement would be completed, let alone give evidence as to how realistic that unknown timeframe was. No weight should be afforded to such a speculative and uncertain future endeavour, particularly given the track record of modification by government in recent weeks. It's common ground that there are no public rights of way or railway station in the vicinity of the site. Upon a plain reading of CSP 7, to comply with the policy, all 4 criteria should be met. The second criteria requires that it should provide a safe and convenient access to public transport and the highway network. It's implicit that the policy requires that there's a safe and convenient access to public transport by foot. Reliance upon an adult driver to drop off pedestrians at the bus stop is unattractive. All of this, in a sense, is OTOs, as there is no evidence that any of the site occupants have ever used any of the local bus services. There's no mention whatsoever in the written evidence or during the lengthy oral evidence. Miss Wilson encapsulated the approach in evidence in chief when she said that she drove everywhere. In cross-examination, Mr. Brown's riposte appeared to be along the lines that gypsies do not tend to use buses, but prefer the car. That's as maybe, but it does not excuse or mitigate that the site is itself private car dependent. National policy does not carve out an exception for gypsy sites from the general rule that new development should not be car dependent. For the first time in Mr. Brown's oral evidence, it was contended that CSP7 is not in fact a development control policy, but is a strategic policy. This was not a point put to Miss Moulton in cross-examination, and indeed it flies in the face of Mr. Brown's written evidence. Whatever the exact status of CSP7 and the merits of this taxonomical controversy, it does not get the appellants anywhere. Mr. Brown agreed in cross-examination that a policy can perform both functions. It can provide a criteria to judge the acceptability of a given proposal and to guide an allocations DPD. In these circumstances, there is no reason why CSP7 cannot be used as the criteria to judge the acceptability of this appeal. You, ma'am, are invited to find that the appeal offends CSP7 and CSP1 in that it fails to comply with the requirement that all new proposals be accessible to all users. I turn next, ma'am, to the benefits of the appeal. It's common ground that there is an unmet need. The 2020 GTAA undertaken by reputable and experienced consultants finds that there's a 5-year supply shortfall of 5 pitches. Over the whole 16-year assessment period up to 2037, the GTAA identified an overall shortfall of 7 pitches. The parties agreed a non-aggression pact, agreed to disagree about the extent of the shortfall. In these circumstances, ma'am, you might be attracted to the formulation that the shortfall is not less than 5 pitches. During the course of the inquiry, it became clear that the appellants have seriously overstated the extent of the shortfall. It was the appellant's written case that on the council's own GTAA, there was an unmet need of 28 permanent pitches. But in evidence in chief, Mr. Brown agreed that it was in fact 14. The issue of need is an important matter which properly weighs in the appellant's favour. That said, there is a danger of the appellants over-egging the pudding. In Mr. Willer's opening, he identified the following material considerations: 1, national, regional and local need; 2, failure of policy; 3, lack of 5-year supply; 4, personal need of the site occupants; and 5, lack of alternative and available sites. This is a categorisation commonly promoted by appellants in case of this sort, but ultimately, ma'am, these are different expressions of the same fundamental point. It's common ground that the best interests of the children are met by allowing them to stay on the site, and that significant weight should be afforded to this consideration, particularly given the vulnerability of Master Thomas James Wilson. That said, the weight to be given to this consideration is tempered by the fact that the 4 families have chosen to educate their children formally up to primary school age only. From 11 years old, the families turn their backs on formal education and rely upon tutoring. This appears to be modest. Miss Wilson confirmed in her evidence in chief that the families pay for a tutor to come to the site once a week, spending only 1 hour with each caravan. This is not a case where there are children who aspire to obtain qualifications, such as GCSEs and A-levels, whilst attending secondary school or college. It's the appellant's case that the tilted balance applies, such that the appeal should be allowed unless you, ma'am, are satisfied that the harms identified significantly and demonstrably outweigh the benefits. This is not accepted. It's the council's case that the tilted balance does not apply in gypsy cases, given that there is a separate national policy regime governed by PPTS. PPTS sets out separate and different presumptions for decision making. So, for example, rural areas are acceptable in principle for sites in a way which is not the case for the settled community. But if you, ma'am, take the contrary view, it's admitted that CPS is not out of date in any event. So by way of conclusion, for the reasons given, the council says that the site is not sustainable or an appropriate location for residential use. In the event that it's decided that temporary consent is apt, it is common ground that the period should be for 4 years. And for those reasons, ma'am, you're invited to dismiss the appeal.
Thank you very much, Mr. Smythe. And Mr. Willers for the appellant, please.
Do you mind if I just quickly skim through this?
Yep, just make sure it's all, yes.
think I ought to turn my microphone on. And then secondly, apologise for any typographical errors. Thirdly, for formatting errors, which despite having spent probably the best part of a couple of hours trying to remedy, appear to have sprung up again on printing. And it's no doubt because I've been working on an iPad with a particular form of document production and it then being converted to Word. And the iPad hasn't done that. So apologies for that. Then can I say, I will comment briefly on Mr. Smythe's closing submissions as I go through, as I remember to do so. What I was going to ask though, Mr. Smythe, to just identify is one point. He said in paragraph 16 as that the appeal offends not just CSP 7, which I think we've all been looking at in some depth, but CSP 1. I don't remember CSP 1 getting a mention either in the council's case or indeed in the inquiry. I just, if it's, I might have missed it. It's paragraph 16.
Yeah. Well, that's no sign on my part. I don't want it to be tricksy. If it wasn't mentioned in the evidence, you can strike.
Okay, thank you.
Line for that part of it.
Thank you.
I similarly don't recall it. I left that for you. Yes, thank you.
Thank you. Thank you very much. So perhaps I can begin by also indicating that I don't intend to read exactly every paragraph because there are some paragraphs where I repeat material that you have copies of. And so you'll forgive me if I paraphrase some of the submissions. I begin, again, paraphrasing by introducing the context in which these submissions are made in paragraph 1 and reverting back to the main issues in paragraph 2, which you, Madam, outlined at the outset of the appeal. I say that the appellants agree with that summary and then we'll address them in the following order. And then I set out the order, which I hope is reflected at the very least in the headings in the following paragraphs. And I start with planning history as a heading. The planning history of the site is agreed between the parties. The site has the benefit of planning permission dating back, I think, to 1991 for use as a wholesale nursery and is previously developed land. The appellants first applied for planning permission to develop the site in 2018. That application was withdrawn. They submitted a fresh second application in 2019. It was refused by the council on the 28th of June 2019. The appellants and their families developed and moved onto the site in May of 2020. So at the, and it's worth remembering this throughout, at the beginning of the lockdown for the pandemic. And they submitted a third planning application for determination at the same time. That application was dismissed and is now the subject of this appeal. In the next paragraphs, I deal with the issue of gypsy status. And Madam, you'll appreciate that it's agreed between the parties that the appellants and their family are entitled to gypsy status. I identify, and you'll see the formatting problem begins here, the paragraph in Planning Policy for Traveller Sites, PPTS, and in paragraph 5, I say the site residents are ethnic Romani gypsies, and it's agreed by the council they also qualify for gypsy status having regard to the policy definition set out above. As a consequence, the government's planning policy in PPTS is a material consideration in this appeal. The fact that the site residents are ethnic Romani gypsies is also of great importance. As such, they're entitled to respect for their traditional way of life, an integral part of which involves living in caravans. And I've referred you to the Chapman case, which you have a copy of. And the quote in paragraph 96, which is to be adhered to by the state and its officials, and I'm afraid that includes inspectors in appeals like this. Paragraph 96 stating that the vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and their different lifestyle, both in the relevant regulatory framework and in reaching decisions in particular cases. To this extent, there is thus a positive obligation imposed on the contracting state by virtue of Article 8 to facilitate the gypsy way of life. And I finished that paragraph by saying clearly these are principles which need to be taken into account when you determine the appeal. The likely location of new gypsy sites in the borough, I suggest, is a relevant consideration, and I deal with that in paragraph 7. As Mr. Brown explained in cross-examination, it's likely that any private new gypsy sites in the borough will be located in the countryside. Gypsy sites are unlikely to be located within settlement boundaries, given the cost of land within urban and suburban areas, the competition for such land, and the likely conflict that a proposed gypsy site would cause to policies designed to ensure that such land is used to its maximum capacity. That is a context which we say this appeal should be determined in, and that is a factor that we say should be taken into account when determining the weight to be attached to any harm arising from the development of the site in this case. I then deal with sustainability, and in doing so, I'll make sure I cover off what Mr. Smythe has to say. The council argued that the proposed development conflicts with policy CSP7 in that the site residents cannot safely access public transport on foot, given the nature of the route along the verge of the busy stretch of the A53 Newcastle Road to local bus stops on the adjoining A51 Nantwich Road. Policy CSP7 does not require that sites provide residents with safe and convenient pedestrian access to public transport, nor is there any such requirement in PPTS or the MPPF. As Mr. Brown explained, policy CSP7 is a strategic policy designed to guide the council on its identification and allocation of sites to meet the unmet need in the borough, albeit dating back to 2009 when it was formulated and adopted. Sensibly, policy CSP7 is qualified by the words "wherever possible" in the text, given the likely location of new sites in the countryside for the reasons set out above. However, it's perhaps not surprising that the unmet need for sites has not yet been addressed if the council are, as I think Mrs. Moulton suggested, interpreting policy CSP7 as strictly as she has done in this instance. In his proof of evidence, Mr. Brown refers to decisions of other planning inspectors, in particular the Willow Park decision, and I've given you the relevant paragraphs in the decision letter. Though each case must be decided on its own facts, the approach taken by your fellow inspectors, madam, in those appeals is one which we invite you to adopt in this appeal. In conclusion, we submit that the council's refusal of plan permission on grounds that the site would not provide its residents with safe and convenient pedestrian access to public transport does not stand up to close scrutiny. We go on to deal more generally with sustainability and refer you to paragraph 13 of PPTS, which takes a holistic approach, if I can put it that way, and say in paragraph 15 over the page, it has not been suggested that the site is generally unsustainable, nor indeed could it be. The site has both good and safe accessibility to primary and other main roads and to major principal urban areas, and there are important benefits that would flow from the grant of planning permission in this case, by virtue of the fact that the site will provide its residents with the wider benefits of easier access to education, health, and other essential services, reduce their need for long-distance travelling, and give them a safe and secure home. And I've referred you to Mr. Brown's proof. Any references like that you'll see to Mr. Brown or Mr. Moulton in the paragraph number. In the circumstances, we submit that the proposed development ought to be considered sustainable for the purposes of PPTS, and that its sustainability ought to weigh in favour of the appeal. Furthermore, the site is affordable and has been provided at no expense to the council or its taxpayers. When those factors are coupled with the fact that the site enables its residents to integrate with the local settled community, then it can be seen that the site is sustainable economically, socially, and environmentally. Just dealing with my learned friend, Mr. Smythe's submissions. He said in paragraph 14, with reference to Mr. Brown's cross-examination, that Mr. Brown said that gypsies as a generality do not tend to use buses, but prefer the car. Obviously, that is a generality, very much so. But the point he also made in cross-examination was that the requirement that there be safe and convenient access, not pedestrian, but convenient access to public transport, was there to ensure that residents had a choice. Not that they necessarily needed to exercise that choice in one way, in other words, to take the bus when they might prefer to take a car. to travel to reach facilities, shops and services and the like. Now, there's also in paragraph, sorry, forgive me, just looking at Mr. Smythe's submissions, we've deleted from paragraph 16 the reference to CSP1, so I don't need to address that. Thank you. Turning to the effect on the character and appearance of the countryside, in paragraph 18, I say policy CSP7 is an out-of-date strategic policy. Nevertheless, it includes criteria which have been used by the council as a yardstick against which, that should read, to determine the appellant's application and applications. Criterion 4, when paraphrased, states that wherever possible, new pitches should be located on sites which minimise any negative impacts upon local landscapes, environments and neighbouring communities. It's been agreed between the parties' planning experts that the yardstick or test laid down in policy CSP 7.4 must be whether the proposed development's impact on visual amenity and the character and appearance of the surrounding area is acceptable, having regard to those considerations, or whether the harm can be reduced to an acceptable level by the imposition of conditions. Before addressing that test, the appellants invite you, Madam, to note that there was no requirement for gypsy sites to be hidden from view, either in the development plan policies or the national policy PPTS. And that policy C of PPTS makes clear that some sites will be in rural areas and the countryside. Indeed, the fact is, as Mr. Brown said in cross-examination, any new gypsy site in the borough is likely to cause a degree of harm to visual amenity, given its likely location and the very nature of such development and its characteristic features, the paraphernalia, the caravans and so forth that go with it. Madam, you've visited the site today and viewed it from public vantage points, and you'll reach your own conclusion on the impact of the proposed development on the character and appearance of the surrounding area. However, the two planning experts called by the appellants and the council have given their own views on the point, and no doubt you'll want to consider whether either view ought to be accepted. The appellants admit that Mrs. Moulton's view does not stand up to close scrutiny, and that Mr. Brown's opinion ought to be preferred for the following reasons. First, it will be noted that the council did not refuse the second 2019 planning application on grounds that it offended criterion 4 of CSP 7. Mrs. Moulton wrote the officer's report, prepared for the determination of that planning application. Of the second. I think that might read this. That might, in fact, be the third application. That's the third application. Yeah. So if you wouldn't mind changing that, the application we're now dealing with on appeal, and I think I've identified that as the third application in an earlier paragraph. In paragraph 1.8 of the officer's report, Mrs. Moulton acknowledged the stance taken by the council when considering the, and that should read the second application, we're one back, but advised that and that should read the third application, as applied for and as built, incorporates an acoustic fence around the site. And she said that it is considered that this new feature has the effect of giving the impression that the site and its occupants are deliberately isolated from the rest of the community, and also diminishes the openness of the area compared to the more open arrangement previously proposed. Then in paragraph 1.9 of the officer's report, Mrs. Moulton advised the council that by enclosing the site now, it is considered that the balance in terms of impact on the character of the area now weighs against the proposal, and it can now be reasonably concluded that the proposal should be refused on the grounds of unacceptable impact. That recommendation was accepted by the council, and the reason for refusal in the decision notice issued on the 20th of August 2020 explicitly states that the proposed development results in harm to the intrinsic character and beauty of the countryside due to the enclosure of the site affecting the character and openness of the landscape. Subsequently, Mrs. Moulton made the same points in her proof of evidence. However, as Mr. Brown explained in his written evidence, and later in his examination in chief and cross-examination, Mrs. Moulton had misunderstood the development proposal by misreading the site layout plan. The acoustic fence was not intended to wrap around and enclose the site. Rather, it was shown on the plan as running along a part of the eastern border of the residential area of the site. During her examination in chief, Mrs. Moulton volunteered the fact that her written evidence was wrong. However, Mrs. Moulton did not go on then to explain in examination in chief the basis on which the council maintained its objection. When cross-examined on the point, Mrs. Moulton volunteered for the very first time an opinion that the proposed site layout would nevertheless give rise to an unacceptable impact on the character and appearance of the countryside, because the residential area still presented as an enclosed area. And although I haven't gone into detail, and you'll have a better note than me, having been cross-examining at the time, I think the key concern was the location of the amenity buildings. But I'll leave you to look back at your notes on that, madam. Putting aside the fact that Mrs. Moulton's new point had never previously formed the basis for the objection, and might, perhaps uncharitably, be thought to have been advanced in order to save face, the fact is that it does not have any merit. Even if, madam, you were to conclude that the location of the amenity blocks have an unacceptable impact by virtue of them playing a part in enclosing the residential area, there is a very simple solution. A condition requiring the council's agreement to a new site layout plan and the relocation of the amenity buildings could be imposed on the grant of planning permission. And I've referred you to paragraph 28 of the PPTS in so far as that is relevant. In the circumstances, we invite you to conclude, as Mr. Brown has done, that the proposed development is acceptable in terms of its impact on the character and appearance of the surrounding countryside, or that it can be made acceptable by the imposition of conditions relating to the site layout and landscaping, requiring that suitable schemes be agreed with the council. In the event that you conclude that the proposed development does in fact give rise to unacceptable harm to the character and appearance of the countryside, then the council argued that there would also be a conflict with the Save Local Plan Policy N20 and the Neighbourhood Plan Policy DC2. I just deal with this briefly in the following paragraph. As Mr. Brown explained in examination in chief and cross-examination and his proof of evidence, Policy DC2 ought to supersede Policy N20. Policy DC2 is less restrictive than Policy N20. It does not suggest that planning permission should be refused. I think that should read if a development proposal does not maintain or enhance the character or appearance of the landscape, just that it will not be supported. In any event, as Mr. Brown explained, neither policy can frustrate or override a strategic policy. And he referred you to paragraph 29 of the MPPF in that regard. And so, insofar as there is any conflict with policy CSP7, that strategic policy ought to prevail, notwithstanding its own inherent faults, which I'm about to turn to. So you'll see that the battle lines are drawn between myself and my learned friend as to the question of whether or not policy N20 conflicts with DC2, and Mr. Smythe dealt with that in paragraph 11 of his submissions. We say there is a plain conflict between the two, and DC2 ought to be therefore preferred, and Mr. Smythe says the opposite. The presumption in favour of sustainable development is the next topic. We invite you to conclude that development plan policy most important for determining, and I take those words from the MPPF, most important for determining the appeal, that being policy CSP7, is out of date, and that in accordance with paragraph 11D of the MPPF, the presumption in favour of sustainable development should apply, and that planning permission should be granted unless any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole. Footnote 8 to paragraph 11 of the MPPF gives decision makers examples. It's not necessarily an exhaustive list, examples of situations where policies are out of date. And that includes where applications involving the provision of housing involve situations where the local planning authorities cannot demonstrate a 5-year supply of deliverable housing sites. brackets with the appropriate buffer as set out in paragraph 74. The question whether policy CSP7 is out of date was the subject of expert evidence. Mr. Brown addressed the point briefly in his proof of evidence. In cross-examination, it was put to Mrs. Moulton that policy CSP7 was out of date because it predated the MPPF and both versions of PPTS, and was not underpinned by a 5-year supply of deliverable sites. In re-examination, it was put to Mrs. Moulton that paragraph 74 of the MPPF had some bearing on the issue in the context of traveller site applications. I don't have a record of Mrs. Moulton's answer. However, Mr. Brown was very clear in examination in chief, stating that the reference to footnote 38, stating with reference to footnote 38, that paragraph 74 of the MPPF had nothing to do with the question of whether a policy was out of date. Madam, I'll leave that for you to review. If, as the appellants suggest, the policy CSP7 is out of date, then the question for you, Madam, must be whether any harm found to arise from the proposed development would significantly and demonstrably outweigh the benefits when assessed against the policies in the MPPF taken as a whole. I turn now to consider other material considerations. And in doing so, begin by saying that any harm arising from the proposed development of the site is, we submit, outweighed by a number of other material considerations, whether taken individually or in combination. The need for gypsy sites. You're required, we submit, with reference to paragraph 24 of the PPTS, to take account of the national, regional and local need for gypsy and traveller sites before considering separately the need of the site residents and their family for such a site. Contrary to what my learned friend says, they're not all, this doesn't all amount to need, personal need, lack of alternative accommodation. They're not all the same thing. They are individual and separate factors that need to be considered. One could have a need, but an alternative site to which the residents might turn. So one would take account of the general need, but at the same time, they wouldn't have the additional issue that they might be able to otherwise argue should be prayed in aid in favour of an appeal if there is an alternative site to which they might be able to go, but they wouldn't want to go. So these issues are separate and need to be assessed separately and insofar as they can be given different weightings. So having established the principle in paragraph 38, we say in paragraph 39, there can be no doubt that there is a clear and urgent need for additional site provision to gypsies and travellers in England and Wales, and particularly within the West Midlands. That general need should be given significant weight in this appeal. In addition, it's agreed that between the parties that there is an unmet need for additional gypsy and traveller site provision within the borough itself. It's an unmet need that was recognised back in 2009 when policy CSP7 was drafted, and then by the authors of the Gypsy and Traveller Accommodation Assessment, GTAA, conducted in 2015, and more recently by the authors of the 2020 GTAA. The extent of the need is a bone of contention between the parties, and Mr. Brown explained his view that the 2020 GTAA underestimates the need for the reasons he gave in his proof. Turning to the next heading, does the development plan address the unmet need? I begin by saying that said, following on from Mr. Brown's underestimate point, it is not necessary, we would suggest, for you, Madam, to reach any conclusion on those points in this appeal, given the Council's agreement that an unmet need exists and that it does not have a 5-year supply of deliverable sites to meet even the level of need identified in the 2020 GTAA. Those facts should also count in favour of the appellant's appeal and be given significant weight. Just as an aside, and perhaps as an example of the fact that one can't literally lump these factors together and treat them as one can see from PPTS, and I think it's paragraph 27 of PPTS, that in terms of assessing whether or not to grant temporary planning permission, PPTS expressly provides that decision makers ought to treat the lack of a 5-year supply as a significant material consideration. We would suggest that the same ought to be applied, same level of weighting, as it were, ought to be applied whether you're considering permanent or temporary permission. But the PPTS guidance is clear that it certainly should be attributed or treated in that way when you come to consider whether or not to grant temporary permission as an alternative. We then deal with the question of the availability of alternative sites. And I'll begin by just outlining the law, as it were, and with reference to the Julie Brown case, which you've got a copy of, and paragraph 37, which endorsed an approach taken by Inspector Drake in that case. But in paragraph 43, I say in this instance, it is in fact agreed that there are no alternative sites that could accommodate the site residents. And that is another separate factor which ought to be weighed in favour of the appellant's appeal. I then address the personal accommodation needs of the site residents, separate from their personal circumstances, because they could have the most telling personal circumstances, but be quite happy to move into a house. That isn't the case in this instance. They have a clear preference for accommodation in accordance with their traditional way of life. In other words, living in caravans, an integral part of the ethnic gypsy way of life, as we've seen recognised in the Chapman case. So I say this in paragraph 44, the site residents are all ethnic Romany gypsies. They have a personal need for pitches on which they can live in their static caravans in accordance with their traditional way of life, and for a site on which they can live together so that they can provide each other with much needed care and support. Turning to the personal circumstances. The appellants gave evidence at the inquiry and explained how they came to buy the site, seek planning permission on 3 occasions, and then moved on to the site at the time they submitted the 3rd application in May 2020. They began the planning process by trying to abide by the rules, but admitted that they moved on to the site 17 months ago in breach of planning control. They did so out of necessity. By May 2020, as COVID lockdown restrictions took effect, sites closed their gates and they were no longer able to travel. Indeed, none of us were. And with concerns about the risk of infection and how it might affect their families, given the cramped and limited nature of their temporary bases, they explained that they felt they had no option but to leave the sites in Sandbach and Stafford and move on to the appeal site. Since then, they've abided by the terms of the status quo injunction. They replaced 2 touring caravans with 2 static caravans, commonly known, I think most people would agree, as mobile homes, with the agreement not of the borough solicitor, but Mrs. Moulton, planning officer. So perhaps rather undermines the point made by my learned friend in, what was it, 9 paragraphs of his closing submissions about the behaviour of the appellants. They also sought advice from an enforcement officer known as Mr. Lehman, I hope I've got his name right, pronunciation in any event, on the stationing of the movable stables, and understood that he had advised them that bringing it onto the land would not breach the injunction. We heard from Mr. Lehman after the parties had closed their case, and he said he did not remember having given the appellant such advice. Whether he did or did not give them that advice, or advice which they understood to be of that effect, is not likely to improve either party's case. Though it is worth noting that the terms of the injunction prohibit the erection of any structure building, stroke building, I should say, and it might well be thought that a movable stable block would not offend that prohibition. Against that background, it's submitted that little weight ought to be given to the intentional unauthorised development point raised by the council at the inquiry, or indeed, I should add, much of what my learned friend said in his closing submissions. Turning briefly to the circumstances of the families, it is perhaps first worth noting the evidence they gave about the difficulties associated with living on the Sandbach and Stafford sites, which starkly contrast with the fact that each family now enjoys the benefits of their own toilet and washing facilities, electricity and running water. Simple comforts, which many of us take for granted, but they appear to treasure. And I've referred you to the compelling evidence, I'd suggest, of Mrs. Dawn Wilson in that regard. Under the heading of health and education, I say this: when considering the weight to be attached to the site residents' personal circumstances, we invite you to note that the government clearly recognises that it is in the public interest that there be provision of sufficient sites for gypsies and travellers in order to improve their general health and well-being, and to conclude that their needs will not properly be met unless they have a stable and secure site from which to access healthcare and educational provision. The families are all registered with local doctors. Some of the adults have health conditions. Leanne Clee, for example, suffers from arthritis in her knee and shoulder, and Eleanor, and I think that should be Eleanor Clee, Thomas Clee's wife, suffers from a severe and degenerative level of hearing loss. There are 10 children living on the site. 2 of them have healthcare needs which require specialist treatment. And then I take you to the documentary evidence relating to Thomas James Wilson, aged 9, who is, one could safely describe profoundly disabled. As the documentary evidence explains, he suffers from Mowat-Wilson syndrome, Hirschsprung's disease, epilepsy, and global development delay, and has had many operations in his young life. One can only imagine how difficult it must be for his parents to care for Thomas James on a day-to-day basis, let alone what it must have been like for his mother when they were living in a tour caravan with basic facilities on the Stafford site. Fortunately, as Caroline Escott explains in her detailed letter, Thomas James has been placed in the Horton Lodge School, and he'll be progressing to Blackfriars Special School, which is only 7 miles from Loggerheads, when he reaches the age of 11. I'll leave you to obviously review those letters which relate to his education. Leo Clee, age 7, suffers from leukemia and is on a 5-year treatment plan. He has a low immune system and is prone to viruses, which in the current context must have been a source of constant worry for his parents. However, as Mr. Thomas Clee explained in examination in chief and cross-examination earlier this year, his consultant advised, in cross-examination, earlier this year, his consultant advised that Leo could attend school. And so he began attending Loggerheads Primary School from Easter 2021, and by all accounts enjoys his time in school. Mr. Mark Lee's son, Mark James, also attends Loggerhead Primary School. And it's clear from his examination in chief that Mr. Lee wants his children to benefit from a decent education so that they have the ability and the choice to work in whatever profession they wish when they reach adulthood. That was evidence which you might think is in stark contrast to what my learned friend said in paragraph 19 of his closing submission. I'll leave you to review that without further comment. The other children on the site are home tutored by Mrs. Lynn Jones, overseen, as Mrs. Wilson explained in cross-examination, by Caroline Escott. Finally, and as a general point, it will be noted that the appeal site does not just provide the appellants with a settled base from which to travel and to access health and education. It also provides the families, as Dawn Wilson explained, with an inbuilt support system whereby, for example, they can rely on each other for childcare when needed, in emergencies or otherwise. We submit that all these factors ought to be given substantial weight in this appeal. And in conclusion, and it's a provisional conclusion, we invite you to conclude that the planning appeal should be allowed and that permanent permission be granted with appropriate conditions. I then deal with temporary planning permission. In the alternative, we submit the temporary planning permission ought to be granted for at least 4 years in line with the recent Greenbelt appeal decision relating to another site in the borough in order to enable this council to make additional site provision in accordance with PPTS. Just as an aside, I haven't up until this point made any mention of HS2, and perhaps you won't forgive me, or you'll forgive me for not having done so, because I don't suggest that HS2 and the possibility that it will end up with the Newcastle Road or the stretch of it being closed off is so significant a consideration that it should necessarily be given much, if any, weight in this current appeal. But if temporary permission were granted for the period of 4 years, if you concluded that permanent permission could not be on the current case, then in 4 years' time, we might have a much better understanding of where that project lies and the timetable for the closure of that part of the road, if indeed it is to proceed as planned. Paragraph 56. If provision is made by this council, additional site provision, then the site residents will have the chance to locate and then obtain planning permission for the use of another part of the land in the borough. In the meantime, the site residents would have the benefit of a settled and secure base from which they can access healthcare and educational facilities, and they would not have to suffer the hardship and deprivations that a forced nomadic way of life would necessarily entail. I then addressed human rights and say that if, notwithstanding all the arguments we put in the preceding paragraphs, you're not persuaded that planning permission ought to be granted, whether permanent or at the very least temporary permission, then we invite you to consider whether the refusal of, and I'm going to put it on this basis, temporary planning permission, the least intrusive measure, as it were, would place a disproportionate burden on the site residents such that it would violate their rights protected by Article 8 of the Convention. I set out Article 8 in paragraph 58. In 59, I draw your attention to the test of proportionality set out in a case called Bank Mellat against Her Majesty's Treasury, number 2, 2013 judgment. And there's a quote, which I'm not going to read out now, from paragraph 20 of the judgment. It's the judgment that we haven't provided you, but I'm hopeful that there's no dispute that that is the appropriate test to be applied. The relevance of the decision in Chapman is a matter that I then address in paragraph 60 onwards. I don't think that it's going to benefit anybody if I read out those paragraphs, if I leave those to you, unless my own friend would like me to read them out. Thank you. Thank you. It amounts to this. What we say is that Chapman is a case which established a number of principles, human rights principles, that are applied in the UK in the domestic courts. In fact, Mrs. Chapman lost her application before the European Court of Human Rights, but bear in mind it was a Greenbelt case, and it was a case where the facts were slightly different. There was a suggestion that there might be alternative sites, or at least there was no evidence that there was not an alternative site for Mrs. Chapman to go to, and so the court was not convinced of her case. And in paragraph 68, we say this: bearing in mind all the circumstances, including the positive obligation on the state to facilitate the Gypsy way of life and the best interests of the appellant's children, we submit that the outright refusal of planning permission would be a disproportionate measure and amount to an unjustified interference with the rights of the site residents, which are protected by Article 8 of the Convention. I then deal separately, because we must, with the public sector equality duty. I refer you to the provision in the Equality Act, section 149 of the Act, and I provide you with an approach which we say you ought to take. I apologise again for the formatting, because it just makes it very difficult to understand. But again, I don't intend to read that out, but if I can leave that to you, Madam. As far as conditions are concerned, in paragraph 70, I say if planning permission is granted, then conditions will need to be imposed in order to ensure that concerns relating to noise, highway safety, the protection of groundwater and ecology are properly addressed. In addition, the appellants agree that other conditions ought to be imposed in order to minimise the impact of the proposed development on the character and appearance of the surrounding countryside, and to ensure that the site is not used for commercial purposes. The appellants are willing to comply with such conditions and to undertake groundworks and the installation of a sewage package treatment plant, works for which Mr. Brown estimated could cost in excess of £5,000. Even if they're only granted temporary planning permission, they consider such a cost a relatively small price to pay, when compared with the alternative, which would be a life on the roadside for the next 4 years. I can just flick through my learned friends' submissions before closing. In conclusion, then, Madam, and perhaps this is the point I take from my own friend's submissions. I'm sure you don't need reminding, but we're not dealing with an application for committal for contempt of court for breach of an injunction. In fact, there was no application for contempt for breach of the injunction made by this local authority. Rather, your job, your task is to evaluate the respective planning merits cases advanced by the parties. And we would submit that in this instance, having regard to all the evidence you've heard from the parties, that it would be appropriate to grant the appellant's permanent or at the very least temporary planning permission for the use of the site as the Gypsy Caravan site, subject to appropriate conditions. Those are our submission. Thank you.
Thank you very much, Mr. Willis. Right, so they're the closings completed. I just need to ask whether or not anybody wants to make an application for costs.
No, Madam,
No.
we've not.
No, thank you. Right, so it just leaves me to thank the council for the organisation of the event. It's gone very well. It's been very comfortable for everybody in the circumstances. Also, thank you to the IT and the support we've had from the back there in being able to live stream the event. And finally, for me to wish you all a very happy Christmas. It's only 30 shopping days, just throwing that out there. And so, yes, so a safe journey home, and the inquiry is now closed. Thank you very much. Thank you. Yes, thank you.